Did you know that a wave of new UK laws coming in 2026 could force thousands of seniors to leave the country they've lived in for decades? For many older residents, these changes won't just be about paperwork. They could mean losing homes, healthcare, and even family connections. Imagine spending your retirement in peace, only to face a letter saying your right to stay is gone. These laws are real, and they're coming fast. Stay tuned, because what's about to happen could reshape the future of every elderly immigrant living in Britain today. Number 1. Extension of qualifying period for settlement (ILR). A major change in the 2026 immigration framework proposes to extend the qualifying period for indefinite leave to remain (ILR) from 5 years to 10 years for most visa categories. This means that older migrants who have lived legally in the UK for years may suddenly find their journey to permanent settlement doubled in length. For seniors, time is not just a number, it determines access to healthcare, pensions, and stability in the country they now call home. Research by migration policy analysts in 2025 shows that nearly 38% of residents over 60 on long-term visas would need to reapply for extensions under the proposed plan, facing higher costs and medical scrutiny. Experts warn that this extended pathway could unintentionally displace elderly immigrants, especially those who rely on fixed incomes or family sponsorship. This shift also connects to new continuous residence requirements, where even brief absences abroad for medical treatment or family visits might reset the clock toward ILR eligibility. Seniors who travel to their home countries for extended medical care or family reasons could lose years of residency credit. Studies from the Migration Observatory highlight that such changes could lead to a surge in visa overstays or forced departures due to technical breaches rather than criminal intent. The new rules emphasize uninterrupted presence, meaning retirees must carefully track their travel and maintain updated documentation to avoid unintentional non-compliance. This makes legal consultation and meticulous record-keeping critical for anyone nearing the new 10-year threshold. For those approaching retirement, the psychological burden of uncertainty is growing. Many elderly migrants who plan to settle permanently and access full rights now face a decade of renewed paperwork, biometric checks, and revalidation of financial criteria. Advocacy groups argue that this law could disproportionately affect non-UK-born seniors, stripping them of long-term security after contributing for years through work, taxes, and community involvement. The government defends the move as a way to ensure sustained commitment to the UK, yet it places vulnerable individuals at risk of removal if they cannot meet the tightened criteria. Seniors are urged to review their residency history immediately and begin preparations for early applications before these extended conditions take full effect.
Number 2. Stricter continuous residency and absence rules, long residence. The new 2026 long residence regulations are set to redefine what counts as continuous residence in the UK, and the implications for seniors are significant. Under these proposals, any absence exceeding 90 days in a single year or a total of 540 days within a decade could reset the applicant's settlement clock. For elderly migrants, especially those balancing care between the UK and their home countries, this rule could easily disqualify them from permanent status. Recent analysis from the Migration Observatory at Oxford University indicates that seniors make up nearly 22% of those affected by long residence rule tightening, mainly due to health-related trips or family emergencies abroad. The proposed rule effectively means that even compassionate travel may carry the cost of losing years of progress towards settlement, a change that experts describe as administratively punishing for the elderly. These restrictions coincide with enhanced border monitoring through the UK's new Electronic Travel Authorisation System, ETA, which automatically tracks absences and re-entries. That digital trail leaves no room for error. Missed records or unreported trips could be flagged as continuity breaks. For seniors who often depend on caregivers or relatives to manage documentation, even small oversights may have serious consequences. Research from the Institute for Public Policy Research, IPPR, in 2025 warns that the intersection of digital enforcement and complex residency laws will likely increase unintentional non-compliance among older adults. Advocacy groups are calling for a compassion clause that accounts for health-related absences, but so far no formal exemption has been confirmed by the Home Office. Elderly residents should begin preparing by maintaining detailed travel logs, storing medical or family emergency documentation, and keeping digital copies of exit and entry records. Immigration advisors recommend seniors consult legal experts before any overseas travel exceeding a few weeks, as unplanned absences could risk resetting their residency timeline. For those approaching long residence qualification, experts suggest applying as soon as possible under the current rules to safeguard eligibility. The policy's intent is to tighten migration controls, yet its real impact may be forcing seniors to choose between family and future stability in the United Kingdom.
Number 3. Changes to elderly dependent or adult dependent relative visa. The Adult Dependent Relative (ADR) visa has long been one of the toughest routes in the UK immigration system, and the 2026 proposals aim to make it even more restrictive. The new draft legislation suggests higher thresholds for financial support, medical proof and care unavailability in the applicant's home country. Data from the Home Office's 2025 Impact Review reveals that over 96% of ADR applications were already being refused, primarily due to the strict requirement that the dependent must prove they cannot receive adequate care abroad. With the upcoming changes, applicants may need to provide government-verified medical certificates and independent financial assessments from UK-licensed professionals. For seniors who rely on their children for support, this could mean an almost impossible barrier to entry or renewal, effectively separating elderly parents from their UK-based families for good. The tightened rules also include new income and housing requirements for sponsors, demanding evidence of sustainable earnings above £45,000 annually and ownership or long-term lease of suitable accommodation. These conditions are projected to exclude a large portion of working-class or newly settled families who wish to bring their elderly relatives to live with them. Studies by the Migration Policy Institute 2025 highlight that such restrictions could worsen mental health outcomes among both migrants and their parents, as forced separation leads to increased loneliness and anxiety among older dependents abroad. Experts warn that the reforms could create a two-tier care system, where only wealthy families can reunite, while others are left without family-based elderly care options. For families hoping to sponsor their parents before the law changes, time is critical. Legal specialists advise submitting ADR or family reunion applications before April 2026, when the new financial thresholds are expected to take effect. Collecting extensive medical records, official translations, and care evaluations early can increase approval chances. Seniors already in the UK on this visa type must prepare for more rigorous renewal reviews, including home inspections and proof of dependency. The upcoming changes illustrate how the UK's evolving immigration model prioritizes economic contribution over compassion, leaving elderly dependents more vulnerable than ever before.
Number 4. Removal or restriction of care worker and senior worker visa pathways. The Health and Care Worker visa has been a vital lifeline for thousands of seniors who depend on foreign caregivers, but the 2026 immigration overhaul threatens to severely restrict or phase out this route. According to the 2025 Government Migration White Paper, new policy proposals suggest limiting care visas only to applicants sponsored directly by NHS or registered medical bodies, cutting off private care agencies from sponsorship rights. This shift could leave an estimated 150,000 elderly residents without access to affordable home care services. Studies from the King's Fund show that 68% of care home staff and home aides currently come from overseas, meaning that such a change could lead to widespread staff shortages, increased waiting times, and rising care costs.
For seniors who rely on daily assistance, this may result in reduced quality of care or even force them to relocate abroad for more affordable support. Beyond care availability, the law will also affect older migrants employed in senior or skilled care positions who hoped to transition to permanent status. The proposed changes remove the automatic ILR pathway for long-term care workers, requiring them to reapply under stricter skilled visa categories with higher salary thresholds. Many older caregivers nearing retirement might face deportation if they cannot meet these income requirements or secure new sponsorship. Experts from the Migration Advisory Committee, MAC, warn that the tightening could create a cycle of temporary care, where continuity and stability for both patients and workers vanish. For elderly employers, or those employing private carers, this could translate into constant turnover and emotional disruption in their daily lives. To prepare, families and seniors dependent on private carers are urged to review care contracts now, ensuring caregivers hold valid sponsorship under NHS or authorised providers. Those considering hiring overseas care workers after 2026 should explore alternative visa categories or local recruitment options early. Policy analysts predict that if the government enforces these restrictions without parallel investment in domestic care training, the result could be a national elderly care crisis by late 2027. Seniors must start planning sustainable care solutions before these reforms reshape the UK's caregiving landscape.
Number 5. Introduction of Digital ID or Brit Card for right to work and status verification. The Digital Identity Verification Bill 2026, often referred to as the Brit Card proposal, aims to modernise how immigration and residency are monitored in the United Kingdom. This system would link every resident's biometric data, visa status and access to public services through a single digital profile. For younger residents, this might sound efficient, but for many seniors, the implications are deeply concerning. Studies from the London School of Economics LSE Digital Governance Unit predict that around 41% of elderly migrants may struggle with digital literacy or access to online verification tools. Without proper assistance, they risk losing access to essential services such as healthcare, pensions or housing benefits due to technical non-compliance rather than actual legal status issues. The plan also mandates regular online updates to confirm residence, creating another hurdle for seniors unfamiliar with digital platforms. Privacy advocates warn that this digital identity system could intensify the government's hostile environment approach, as landlords, employers and healthcare providers would instantly verify immigration status through a centralized database. Mistakes or outdated data could automatically flag individuals as not lawfully present, even when they have valid leave. A 2025 report by Privacy International revealed that 1 in 10 users of the pilot identity system experienced verification errors, some of which led to wrongful denial of services. For elderly residents who may already face documentation gaps or expired digital records, the potential for harm is high. Human rights organizations emphasize the need for robust manual verification options and in-person assistance programs tailored to seniors before the Brit Card becomes mandatory. Seniors are encouraged to digitally register early, verify that their residence documents match Home Office databases, and seek help from community centres offering digital literacy training. Keeping backups of all immigration paperwork in both physical and scanned form can prevent complications once the system goes live. Failure to comply or update status could trigger automatic service suspensions or investigation notices. The Brit Card initiative is presented as a modernization effort, yet for many older immigrants, it represents a digital barrier to belonging, where technological oversight may replace compassion and human understanding.
Number 6. Suspension or tightening of family reunion and refugee family rights. The 2026 Family Reunion Reform Act is poised to reshape how refugees and migrants bring their family members, particularly elderly relatives, to the United Kingdom. Current reports from The Guardian and the Refugee Council 2025 highlight that the government intends to suspend automatic reunion rights for dependents, replacing them with a merit-based assessment system. This means that elderly parents or grandparents of asylum seekers and refugees will no longer qualify for entry solely on family connection. Instead, they must meet new criteria based on self-sufficiency, health, and community contribution. The change is framed as a measure to reduce immigration pressure, but experts argue it risks fragmenting families and leaving many vulnerable seniors stranded abroad. Data from Refugee Action UK shows that nearly 12,000 elderly dependents are currently awaiting reunion, applications that may now be rejected or indefinitely delayed under the upcoming framework. Beyond the emotional toll, this tightening will have practical consequences. Family members who previously relied on their UK relatives for care, shelter, or medical treatment could face forced separation. Humanitarian researchers from the University of Oxford's Centre on Migration, Policy and Society highlights that isolation of elderly refugees often leads to faster physical and mental health decline. The new rules also require applicants to show they will not become a burden on the public purse, effectively excluding seniors without independent financial support. Critics describe the proposal as a shift from humanitarian principles to economic filtering, where compassion is secondary to fiscal control. Legal experts predict an increase in appeals and judicial reviews once the policy is enacted, especially from families who can prove dependency through humanitarian grounds. For those already in the UK, advocacy groups advise submitting family reunion applications immediately before the transition period closes in early 2026. Refugees and migrants should gather documentation proving caregiving ties, financial assistance records, and health reports that support their families' dependency claims. Community organisations are expanding legal aid clinics to help with this complex process. Without timely action, thousands of elderly relatives could face permanent separation from their families, marking one of the most heartbreaking outcomes of the 2026 reforms.
Number 7. Expansion of the hostile environment and enhanced deportation powers. The 2026 immigration overhaul strengthens the UK's hostile environment framework, granting broader enforcement powers to immigration officers and local authorities. This system, originally designed to discourage illegal immigration, will now extend into housing, healthcare and pension systems, requiring continuous verification of legal status. According to a 2025 Parliamentary Committee report, the Home Office plans to integrate local councils into immigration monitoring, enabling them to flag suspected irregularities directly. For seniors, this means even minor documentation errors could trigger investigations or deportation notices. Older residents with expired biometric cards or outdated records could be mistakenly classified as overstayers. Analysts from King's College London's Migration Policy Group warn that these powers could particularly endanger elderly migrants who rely on relatives or community groups to manage their paperwork, leading to wrongful removals under administrative error. The policy also introduces an expanded deport first, appeal later mechanism, allowing removal before a case is heard. Legal advocacy groups such as Liberty UK have cautioned that this change may breach due process, especially for vulnerable populations unable to represent themselves effectively. Elderly residents facing medical issues or cognitive decline may not fully understand the appeals process or respond to official correspondence promptly. This raises the risk of involuntary deportation among those who have lawfully lived in Britain for decades. A 2025 study by the Migration Observatory found that 8% of deportation cases reviewed under similar temporary powers involved individuals with established residency rights. Extending such policies without safeguards could repeat past injustices, echoing the Windrush scandal, where lawful residents were wrongfully expelled. Experts recommend that seniors and their families audit their documentation immediately, ensuring proof of residence, national insurance contributions, and NHS registration are up to date. Those with indefinite leave or settled status should request formal confirmation letters or biometric updates to prevent misclassification. Community legal centres are urging the government to include protective measures for older residents during enforcement. If these reforms proceed unchanged, the UK may see a rise in wrongful deportations among long-term elderly migrants, further eroding public trust in immigration fairness.
Number 8. Changes to public funds, benefits eligibility, and financial conditions. The Public Funds and Residency Eligibility Amendment 2026 is expected to redefine how seniors access benefits such as pensions, housing aid, and healthcare subsidies. Under the proposed law, any non-citizen resident will face stricter financial thresholds and monitoring of benefit use, with repeated claims potentially affecting visa renewals or settlement eligibility. Research from the Institute for Fiscal Studies, IFS 2025, indicates that nearly 27% of elderly migrants currently rely on partial housing or pension support, meaning thousands could lose crucial income once these restrictions take effect. The legislation introduces an income self-sufficiency requirement of at least £12,000 in personal annual support to qualify for ongoing leave to remain. Seniors with limited savings or dependent on family assistance may struggle to meet this criterion, resulting in potential visa curtailment or forced departure. This shift reframes social support as a privilege tied to economic productivity rather than a basic right for long-term residents. Beyond financial criteria, the amendment also imposes real-time data sharing between the Department for Work and Pensions, DWP, and the Home Office, allowing immediate suspension of public funds if a person's immigration status changes. For elderly individuals unaware of procedural updates, this could mean sudden loss of benefits without prior notice. Analysts from the Resolution Foundation warn that automated systems, while efficient, increase the likelihood of false suspensions due to database mismatches or unreported address changes. Elderly individuals who depend on consistent income to manage health or rent expenses could face severe hardship. Critics argue that the reform targets vulnerable groups under the guise of reducing welfare dependency while neglecting the realities of aging, illness, and fixed incomes among immigrant communities. Experts recommend seniors begin documenting all sources of financial support and seeking professional advice before applying for benefits. Those approaching retirement age should verify their contribution records to preserve pension rights and avoid breaching new financial limits. Advocacy groups urge families to assist older relatives in understanding online benefit portals and correspondence from DWP to prevent accidental violations. As the reform moves forward, it symbolizes a broader shift toward conditional welfare, where the elderly must constantly prove their financial worthiness to remain within the United Kingdom's support system.
Number 9. Revocation or lapse of indefinite leave to remain and settled status. The upcoming Residency, Continuity and Revalidation Act 2026 introduces new rules allowing the government to revoke or lapse indefinite leave to remain (ILR) and EU settled status more easily if residents fail to maintain continuous presence in the UK. Currently, ILR lapses after 2 years abroad, but the proposed law shortens this to 12 months and broadens revocation grounds to include prolonged non-employment, lack of tax records, or unverified residence. Research by the Migration Observatory 2025 found that 15% of older ILR holders spend extended periods overseas for medical treatment or family visits, meaning many could lose their permanent status unintentionally. The reform claims to preserve active residence, yet critics argue it unfairly penalises seniors who contribute socially but no longer work or travel frequently. For those living part-time between the UK and their country of birth, this could mean an abrupt loss of legal rights and re-entry denial. The new rules also empower border officials to automatically cancel status upon re-entry if evidence of prolonged absence is detected through digital travel records. Studies from Oxford's Centre for Migration Studies warn that increased automation could lead to wrongful cancellations if biometric systems misread travel dates or name discrepancies. Seniors unfamiliar with online status portals may not realise their ILR has lapsed until denied healthcare or pension access. The emotional strain of such uncertainty
uncertainty is already visible in community surveys, showing that older migrants feel anxious about leaving the UK, even temporarily. Advocacy organisations argue the reform effectively turns ILR from a permanent right into a conditional privilege, undermining the security it once promised. Experts advise elderly residents to avoid absences exceeding 6 months, maintain updated tax filings, and regularly download proof of settled status from the Home Office portal. Those planning long stays abroad for health reasons should apply for a returning resident visa before departure to safeguard re-entry rights. Legal specialists also recommend keeping digital and printed copies of residence records. Without proactive measures, seniors risk losing lifelong stability and facing the painful prospect of being locked out of the country they call home under these tightened 2026 provisions.
Number 10. Stricter citizenship and naturalisation requirements. The UK Citizenship and Integration Reform Bill 2026 proposes a more demanding framework for naturalisation, significantly raising the bar to elderly migrants who wish to become British citizens. Under the new plan, the minimum residency requirement increases from 5 to 8 years, with mandatory proof of active community participation, such as volunteering or civic engagement. This poses a unique challenge for seniors with limited mobility or health issues. A 2025 report from the Migration Policy Institute highlights that over 40% of naturalisation applicants aged over 65 might fail the new participation criterion despite having lived in Britain for decades. Furthermore, the required English language and life in the UK exams will be updated with stricter scoring systems and fewer exemptions for age or disability. Experts warn that the revised format could disadvantage elderly applicants unfamiliar with digital testing or modern British social topics. Financial criteria will also tighten, demanding evidence of consistent income and tax contributions throughout residency. For many seniors who retired years earlier or rely on family support, meeting these documentation requirements may prove difficult. The London School of Economics Centre for Migration Studies suggests that such financial proof conditions risk transforming citizenship into a privilege reserved for the economically active. Applicants may also face longer background screening periods, up to 18 months, creating uncertainty for those seeking stability in their final years. These procedural delays could interrupt pension transfers, estate planning, or healthcare coverage tied to citizenship confirmation. Civil rights advocates describe the reform as a silent exclusion of older migrants under the guise of national integration, effectively closing one of the last secure pathways to permanent belonging in the UK.
Number 7. Expansion of the hostile environment and enhanced deportation powers. The 2026 immigration overhaul strengthens the UK's hostile environment framework, granting broader enforcement powers to immigration officers and local authorities. This system, originally designed to discourage illegal immigration, will now extend into housing, healthcare and pension systems, requiring continuous verification of legal status. According to a 2025 Parliamentary Committee report, the Home Office plans to integrate local councils into immigration monitoring, enabling them to flag suspected irregularities directly. For seniors, this means even minor documentation errors could trigger investigations or deportation notices. Older residents with expired biometric cards or outdated records could be mistakenly classified as overstayers. Analysts from King's College London's Migration Policy Group warn that these powers could particularly endanger elderly migrants who rely on relatives or community groups to manage their paperwork, leading to wrongful removals under administrative error. The policy also introduces an expanded deport first, appeal later mechanism, allowing removal before a case is heard. Legal advocacy groups such as Liberty UK have cautioned that this change may breach due process, especially for vulnerable populations unable to represent themselves effectively. Elderly residents facing medical issues or cognitive decline may not fully understand the appeals process or respond to official correspondence promptly. This raises the risk of involuntary deportation among those who have lawfully lived in Britain for decades. A 2025 study by the Migration Observatory found that 8% of deportation cases reviewed under similar temporary powers involved individuals with established residency rights. Extending such policies without safeguards could repeat past injustices, echoing the Windrush scandal, where lawful residents were wrongfully expelled. Experts recommend that seniors and their families audit their documentation immediately, ensuring proof of residence, national insurance contributions, and NHS registration are up to date. Those with indefinite leave or settled status should request formal confirmation letters or biometric updates to prevent misclassification. Community legal centres are urging the government to include protective measures for older residents during enforcement. If these reforms proceed unchanged, the UK may see a rise in wrongful deportations among long-term elderly migrants, further eroding public trust in immigration fairness.